Legal considerations for musicians, the latest in our series of free music business webinars from NWC Webinars and Canadian Musician Magazine. Joining us in the hot seat is Byron Pascoe, entertainment lawyer with Edwards PC Creative Law. Got offices in Toronto and Ottawa, and Byron and his colleagues represent a wide swath of musicians, artists, music industry professionals, music festivals, and the like. A lot of his work has to do with helping clients to understand and negotiate agreements that they may be asked to sign, or conversely to ask other people to sign. We'll be touching a few of those here shortly. And a quick disclaimer before we get any further: this presentation is for general informational purposes only and is not to be considered or confused with legal advice. In such a case, please contact a lawyer, Byron, anyone else, if you wish to apply these concepts in your specific circumstances or for specific legal advice. And edwardslaw.ca is the home base where you can access that very valuable blog. Here we go, Byron, ready to get started. We've got a long list of topics to touch on here. We're going to start with Music Law 101 and basically just race through 20 music law FAQs. So we're going to be throwing a lot at you, just covering kind of a 101 level introduction. If at any point you've got a question pertaining to any of those things, fire it at us. We are here for you. We want to give you the information you need. And then after that, we'll take some questions, and then we'll zoom in on agreements. We'll talk specifically about management agreements and producer agreements, and then we'll cast a wider net, talk about tips to keep in mind with any type of agreement you're asked to sign, minor, major, at any point in your career, and then we'll close it off with red flags in music agreements and contracts, things to keep an eye for and get suspicious about if you encounter. So without further ado, Byron, thank you so much for joining us. Are we ready to jump in here?
Sounds good. Thanks, Andrew.
All right.
Yeah, so these are probably some of the most common questions that I get as a music lawyer. Some of the answers that we'll talk about today merely scratch the surface, and other questions are have some pretty quick answers. So what makes an agreement a legally enforceable agreement? At least here in Canada, the three basic elements are offer, acceptance, consideration. And what that means in practical terms is that both sides need to get something out of it. It doesn't have to be fair, but each side has to get something, which usually leads to the question of, is a verbal agreement a legally binding agreement? And the answer is yes. Now, there are reasons to have an agreement in writing, but if two people have an agreement verbally, then that's still legally binding. You can't be agreeing to do something illegal, but having an agreement verbally or by email, or if you write it or if a lawyer writes it, you don't need to have a lawyer involved to prepare an agreement. So, why would someone want to have an agreement in writing versus a verbal conversation? Well, verbally, people lie. People lie about things, unfortunately, all the time, or they forget. So if you have an arrangement with somebody, you may forget the details of it, weeks, months, or years later. If something is in writing, you have something better to demonstrate what you agreed on. And also, when things are in writing, usually there's more details that are outlined as compared to what would be in a verbal agreement. So for example, we'll talk a bit later about management and producer agreements. If you have an arrangement with your producer or your manager, likely you won't be covering all of the different things that might be in a producer or a management written agreement. The next one is probably the most common question I get. Got it?
Yeah, us too.
How do I copyright a song? So most people think that I'll give you the answer. So the way you copyright a song is by actually fixing it in writing. What that means is that when you have an idea for a beat or a lyric in your mind, that's not protected by copyright. But once you write it out on paper or on your computer, or once you record it in your phone or in a studio, that's what triggers copyright protection, which means that you alone have certain rights to that music that no one else has. That no one else has. You don't need to register it with the government. You don't need to register it with Song Vault. Those different things they provide additional assistance in certain situations, but they don't trigger copyright. So again, how do you copyright a song? Write it down, record it. You don't need to do anything else. We could talk later about Canadian Intellectual Property Office if you want, but I'll leave it at that for now.
All
so
right.
next one is, how do I plan for success in the context of music law? And it kind of leads into the next question of getting things in writing. I think that, you know, if certain songs that you write or perform are more successful than others, the ones that are most successful, you're going to hope that at the time that you wrote or recorded that song, that you had your arrangements clarified with the people that you're working with, and that those arrangements were outlined in writing. So the next question is it too late to get this in writing? And the answer is generally no, meaning that just because you started to work with somebody a while ago doesn't mean that it's too late to get in writing. Oftentimes, agreements that I prepare are dated earlier. So I was writing an agreement today between a client of mine and two people that were featured on a song that he co-wrote and produced and performed. And the date of the agreement was a couple of years ago, because that's when the song came out, as opposed to being dated now. So the point is, you can, what's called backdate. You can have a date, an agreement be dated earlier than when it's actually being signed. So, you know, if someone says, oh, it's too late to get this in writing, you know, that's usually not the case. The next one is about having something in place with your co-writers. Well, should I have something in place with my co-writers? Yes. You know, what should you have in place with your co-writers? Possibly a split sheet. So one of the two documents that which is a document that outlines who the different writers are on a song, on a composition. There are many different types of split sheets that are out there. This just happens to be one that I send to people if they ask. It outlines who the writers are, who owns the master, what the credits are, and I'll leave it at that for now. But the point is that if you're working with other people who are writing a song with you, it's a good idea to outline to what extent each of you have a ownership stake as a percent. Each of you own a percentage of the composition. And if you're writing with somebody or you're working with someone gives you an idea or a few lines or a little beat or something, and you have the expectation that they don't own any of the composition, then get them to confirm that they own 0% of the composition. It's a lot easier to showcase to someone in the future that they agreed to take nothing at the time if they, you know, confirmed in writing that they're not entitled to anything. So take a look at that split sheet. Again, there's different types, and I can answer some questions about that later on.
Apologies ahead of time for the typo here, Byron.
Should my band have a band agreement? That was probably my fault. Should my band have a band agreement? So, you know, many people are in bands, many people aren't, but people that are in bands, it's a good idea, I think, for them to at least discuss you know, what the arrangement is between them. Band agreements are definitely not the most common agreement that I'm asked to prepare or review, even though I would suggest that every band have a band agreement. And actually, a couple of years ago, Andrew and I did a webinar specifically about band agreements, which we outlined a variety of considerations. Some of the most common things to confirm with your bandmates are, you know, who makes decisions, how revenues are split up, how expenses are paid for, who keeps the band name if the band breaks up. There's a variety of things, and if you Google my name and band agreements, then you can find a blog I wrote about that, and Andrew may have the link to the previous webinar about that topic. But overall, it's a good idea to at least discuss these types of issues with your band. It's better to, you know, put it in writing, but at the very least have a conversation. And, you know, feel free to blame me to say you watched this, you know, Canadian musician webinar and this lawyer suggested that, you know, you and your rest of your band talk about these awkward things. So, you know, take it from there. Next question is, what do I need to know about music publishing and who are the key partners? So music publishing can mean a variety of things. The one that's kind of most common, or at least most thought about in the context of music publishing, is placing music that exists into films, television shows, advertisements, video games, etc. There are definitely a variety of other aspects of music publishing, including getting your publisher to connect you with co-writers, getting your publisher to get other people to perform the songs that you wrote, getting your publisher to bring you opportunities to have songs be commissioned for advertisements or films. I've mentioned the word publisher a few times, and in terms of who are the key partners, well, a key partner in music publishing is a publisher. There are other different players in that world, including publishing administrators who go out and help you find your writing royalties. There's also music sync agents that go out and try to find you opportunities to place your existing music into films and TV shows, etc. I think a major takeaway here in terms of this context is what do you need to know about music publishing? Well, I think the most important takeaway is that for any song, for any recording of a song to be in a film, for example, the film producers need two rights: the right to use the master and the right to use the composition. And so you as the artist want to ensure that you alone, or possibly with someone else, own and control the master, and you want to have clarity about who controls the composition. If you're writing for yourself and you have your own recording studio and there's no one else involved and you write by yourself, etc., it's pretty clear that you own the master and that you control the composition. But once you start working with other people, including co-writers, including a producer, etc., that's where additional people get into the mix, and you want to have clarity about who controls those decisions. We can do a whole webinar on music publishing, so I'll leave it at that for now.
Well, and actually, why don't I jump in there and plug? We have done a webinar on music publishing, along with that on band agreements, for which Byron joined us. These are all available where you registered. nwcwebinars.com is where you can always register for our next monthly webinar, and where you can access the archives of everything we've done so far, full video recordings of each. It is a trove, and I'm glad that Byron mentioned, just beat me to the punch. One more before we jump over, just because we're switching and it pertains to something we touched on earlier. So loud and clear that copyright is enacted as soon as that piece of music is written down or recorded or otherwise materialized. But the question here is there, I guess, a general practice that you use or would recommend for someone to be able to easily prove copyright should a conflict arise down the road?
Sure. So what people did back in the day, especially in the context of scripts for films, was that they would mail it to themselves. We have a thing called email now that is quite useful. And so, my suggestion is for any song that you write and record, or even if you're writing a song, if you're writing some lyrics, email it to yourself. If you've recorded a song, email it to yourself and to other people too. There's metadata, and I can't get into the the technical aspect of it, but there is a metadata stamp. There's essentially a date stamp and other information about the timing of when something was made in a in a computer file. But sending it to yourself and other people is helpful. If you're registering it with the Canadian Intellectual Property Office, then what you are essentially telling them is when you created a song. You don't actually send them a copy of the song, though, and one way to deal with that is to have the song be submitted to the Canadian Song Vault, which is a service that Songwriters Association of Canada provides. And if you're registering your song with the US Copyright Office, you actually send them a copy of the song. So there's a variety of ways that you can add, or that you can kind of internally document when works are made. And there are several options regarding third-party depositories of content that's date stamped to some extent that can help to prove that you created something at a certain time. Mm-hmm. I mean, the other, maybe the most obvious one is that if you have a song and you upload it, maybe using DistroKid or TuneCore or CD Baby to get it on digital service, using a digital service provider to get your music onto different platforms, the day that you uploaded it or that it appears on Spotify, clearly you recorded it or wrote it, before that date. So, there's a variety of date stamps that you can that you can attach to your music.
Awesome. Thanks, Byron. Thanks for the great question, Dave. We've got a great one from Tess that I'll put in the queue for our next break, but keep them coming, whether they're relevant to what we're talking about now or general questions, and we will put them in front of Byron. Let's keep it rolling. More FAQs, and
sure.
Here we go. We're getting meaty. Record label agreement.
Sounds good. Yeah. So should I sign a record label agreement? Well, first off, you have to be offered one to answer that question. But the related question is, what exactly does a record label in 2019 do? I just mentioned a few digital service providers that can get your music out there. Record labels, for the most part, used to be more of a gatekeeper with respect to getting music out into the world. Now not so much. What they can provide, though, and what they ideally generally do for people that want to work with them and get offered to work with them is money to pay for recordings, to pay for marketing, a marketing machine generally, and opportunities to work with other people on the label, and generally a lot of credibility depending on the label. So there are reasons to work with a record label, but you could also on your own essentially become your own distributor and marketer. So what are you giving up? Essentially, you're giving up rights in your music, and that those rights could either be for a certain amount of time, or well, it's always for a certain amount of time. It could be for a limited amount of time or forever. You might give up ownership of your masters in your music, and in return, you're being paid some sort of fee, which is there's a variety. Well, there are a few different revenue formulas for an artist and a record label. It might be that you're given a percentage of the profit, or you might be given a smaller percentage of the sales of the music. Yeah, so I'll leave it at that for now. I did write a couple of blogs about record label agreements that are on the website. Next question is, should I incorporate? And I wrote a blog about that too. Usually, people may incorporate in general for tax purposes, essentially to give them more tax flexibility. It's more relevant, at least for clients I've worked with, once they're making, quite a lot of money. I don't want to say when the appropriate time is, to incorporate from a revenue perspective, but I would say to speak to an accountant or get an accountant. And if you want a, suggestion on some music accountants, let me know. But usually it's for tax purposes. And also there are some music grants that require you to be incorporated. What is MFN? So MFN stands for probably a variety of things, but in this context, it stands for Most Favored Nations. And I did write a blog about this too. It's on Bandzoogle actually, and then it'll be on my website in the next few days. Essentially, this is a concept that you can use if, for example, if you're being hired for a gig and there's a variety of performers and you're offered, for example, let's say $250, and you don't know what everybody else is making, you could say, I'll accept $250 on a most favored nations basis with everybody else who's performing, which means that if they agree to that, and if they give someone else $300, then they have to give you that too. Similar type of, you can also work that into music publishing. For example, if let's say a show on CBC, if the music supervisor wants to use your song in an episode of, I don't know, Heartland or something, and they offer you, let's say, $1,000, you could say, okay, I'll accept $1,000 for the rights to use the master and the composition on a most favored nations basis with the other music that's used in this episode apart from the theme song. So if they give some other song $1,500 in that same episode, then they have to give the same to you. It's generally a way to protect, to try to get some more protection when you're talking about, usually about fees that you're getting when other people are also getting paid, and you don't know if you're getting, the best deal that you could. Should I submit to this contest? So usually there's a variety of music contests that are out there, as you know. And sometimes the contests are purely for you, you're agreeing to appear, in the event, probably not being paid. What some contests include is an option agreement whereby the people running the contest have the opportunity to get rights from you with respect to your music and your career. So like anything, I'd suggest, reading the contest documents, agreements, and seeing if they're the right fit for you. And if you have any questions, to ask those questions. And if you think you want to try to negotiate the terms, then try to negotiate the terms. I've been involved in contests kind of on both sides, representing people who ran contests and also helping artists who are on, let's say, TV show contests with the agreements with the people running the show. Next one. So, contests, they could be a great opportunity, but you just need to make sure that you balance out the rights that you're giving with the opportunity that you could get. Can I remix any song I want? Some of these questions are I guess they seem obvious to me, or maybe it's the quick answer is obvious, but the rest of the answer may not be that obvious. Can I remix any song I want? No. You do need permission if you're remixing or sampling. You need permission both to use the master that you're remixing or sampling and the composition. I'll leave it at that. How do I legally perform in the US? Whenever someone asks me that, I direct them to the Canadian Federation of Musicians, CFM, and your local, whichever city you're in or town in Canada. Send them to your local. I suggest people talk to their local of the Canadian Federation of Musicians, and they can walk you through exactly what you need to do and the costs to do that. But they are the people to go to get your P2 visa to perform legally in the United States. And I don't suggest, trying to cross the border and performing without doing it the right way. You don't want to be on their bad side. So at the very least, have a conversation with the Canadian Federation of Musicians well in advance of when you plan to tour in the United States.
Awesome. Keep the questions coming. We've got a lot here, really good ones and very diverse. So this is our last group of FAQs, and then we'll get to these. Thanks for your patience, everyone. Thanks, Byron. This is my pen hand is going crazy. And yeah, I guess this time we're going to speak about music law specifically and lawyers.
Yeah. So the question is, what do music lawyers actually do? So it varies every day, but for the most part, what we do, it's very transactional, meaning we are helping artists and producers and managers and music companies to review agreements that they're asked to sign and to prepare agreements that they want other people to sign. So I mentioned in passing, I guess, that I was reviewing or writing an agreement between my artist client and two people that were that are on one of his recordings. And then, yesterday I'm reviewing a producer agreement that a client of mine is being asked to sign. So it's a lot of reviewing and preparing agreements, and then just helping with other things that come up, namely, professional relationships. So for example, if an artist and their manager are no longer on good terms, may help them to prepare a settlement between them. There ends up being quite a lot of disputes that we deal with, and in many cases, if people had clear arrangements between all the parties involved from the start, they probably wouldn't have a dispute or would not need to have a lawyer be involved. But because they didn't figure things out clearly up front, later on when they do get into conflict, that's when stuff hits the fan, and some lawyers sometimes get involved. So that's what lawyers, from my perspective, what we actually do. When do people engage lawyers? Usually when it's too late, but sometimes early on. So basically, when people have an agreement that they want reviewed, that's when they usually would start to pay a lawyer to do anything. But I think it's a good idea for musicians just to kind of have, one or even two lawyers kind of in their toolbox to kind of, be able to call on at a moment's notice if something comes up, but in advance, to have a relationship, professional relationship with a lawyer, who they, trust, and my 4-year-old daughter may be joining this conversation. Yeah, so I think it's important to kind of have the conversation early on so that when something comes up at the last minute, you know who to call. When can I blame my lawyer? Always, usually in the context of, starting an awkward conversation with your band about having a band agreement. Why are people apprehensive about lawyers? Sometimes it's cost related. Okay. feel like that CNN video where the kid walks in. Oh, good. Very good. Actually, my 7-year-old is on SoCamp, and my 4-year-old isn't there yet. We'll get to that. So the next thing I wrote here is, what are your expectations of me and my music? And these are kind of my favorite 9 words relating to music. And the blog that I gave to Andrew to pass out is this topic specifically. I think that asking these questions to your music collaborators is a good idea, and really can start the conversation, especially if you're dealing with somebody who has more industry knowledge than you. And oftentimes, sorry, 1 second.
Mm-hmm.
I'll be back in 1 second.
Yeah, we appreciate this. Your time is very valuable, and so not hurting anything here. And yeah, as Byron was saying, that blog post, again, you can grab with all of the shared resources, including that split sheet template and breakdown of the presentation here. I suggest grabbing them all and having a quick look. And
I'm back.
What you need. Right on.
Sorry about that. Yeah, so oftentimes I get a call from somebody when they have been working with someone who's a lot more experienced than they are in the industry, and they've been working with them for, on a couple songs or for years, and they've realized that it's not the right relationship that they want to be in professionally right now, and they really aren't sure what they agreed to years ago when they didn't understand anything, it could get complicated and awkward, and it's kind of more common than ideally. It's more common than we'd like. So I think if you don't really know too much about what you're being asked to get into, and someone just says, "Oh, don't worry about it. We'll deal with it later on." I think a good starting point for that conversation is, what are your expectations of me and my music? It's not rude. It's not out of line. It's an appropriate starting point when you're working with someone, whether you're just starting out with somebody as a producer or a collaborator, either when you're starting out or once you're already starting to work with them. And the blog that Andrew handed out covers a couple of different scenarios. One of them is a producer relationship, and one of them is about I forget. I think it's kind of related to producing as well, probably. Yeah, I'll leave it at that. But those 9 words I think are pretty helpful in a variety of situations.
Right on. Speaking of variety, so here we go. Really quickly, Joseph, thank you very much for your question. It's fairly long and fairly specific. I will put that in front of Byron after the session to get you an answer, or at least a bit of guidance with your situation here. So yeah, jumping out, what PROs, PRO, for those unfamiliar, performing rights organizations or societies, so there may be a bit of confusion with the language here, but I'll put this in front, Byron, and hopefully you can clear it up a bit. Which PROs beyond SOCAN/ASCAP, SOCAN being Canada's, ASCAP being one of those in the United States, which PROs should an indie join to get mechanical and neighboring rights on a release record in Canada and the US? Are Resound and the CMRRA sufficient? Should one also join Premier Music? And that is something I'm not familiar with.
Sure. So on neighboring rights royalties, essentially there are royalties that are collected and ideally given to you as a performer and as an owner of master recordings. And there are different organizations that collect those royalties or that give out those royalties. So here in Canada, there's many. Or at least more than the United States. In Canada, from kind of an English perspective, the most common ones for performers are MROC, MROC, and ACTRA RACS, ACTRA RACS, ACTRA RACS. And on the side of the owning your master recording, the most, or one of the two, is called Connect, as in like Connect 4. You can use those organizations to collect your neighboring rights and related royalties either from Canada, that are generated in Canada, or around the world. The related US-based organization is called sound exchange. Sound exchange, one word. What some people do is they use sound exchange for those royalties that are generated in the US, and they use MROC and Connect for the money that's generated around the world except for the US. You could also sign up with Resound alone to capture all of those funds. Or you could use any combination you want. You could use Sound Exchange for, let's say, US and United Kingdom and Australia and Canada for the rest of the world, or MROC and Connect for the rest of the world. Probably the most common, or one of the most common combinations, is just using MROC and Connect for the whole world. Regarding and I forget about, I may have a blog about this, but we can talk. If anyone wants, I can send them the links to these organizations, and they can help to answer, why they're a better organization to work with as compared to the others. On the mechanical side, one avenue is to use a publishing administrator. Song Trust is one option. They put on a variety of really good webinars about music publishing and about collecting mechanical royalties. And I think it would be a good idea to check out their webinars and consider using them. I'm not speaking on their behalf, but they're one option to be your publishing administrator. And so one option to consider is using MROC and Connect, or Actor Racks and Connect, to collect your neighboring rights royalties, and to use Song Trust to access to be your publishing administrator, and then also be registered with SOCAN as a writer. Right. So, we could do a whole session on royalties and stuff, and there are people that could speak to it as well. But I guess that's the answer for now.
All right. Well, yeah, there are a few along these lines.
Sure.
Let's see here. And I think the answer to some of these is pretty straightforward. Which society should a producer join to collect mechanical royalties from indie artists? I assume that means the artists with whom they're collaborating.
So I would say a company like Song Trust to collect their mechanical royalties. The starting point, though, for a producer is to clarify in writing with the artist and any other people that are relevant what percentage of the composition the producer is entitled to. And we may get to that in the context of producer agreements. But if you're a producer and you're being given, for example, 10% of the composition, you want to clarify that you're being given 10% of the writer's share of the composition and 10% of the publisher's share of the composition, and clarifying that you're entitled to collect your own 10% of publishing royalties in the composition. And then you might use Song Trust or someone else to collect your publishing royalties. But by just saying that if you're a producer and an artist comes in and you agree that you're getting 10%, I would say that's not a sufficient. That doesn't provide enough clarity, at least from my perspective. The next best thing would be to use the split sheet that I gave you, or another one that will clarify that you're entitled to 10% of the writer's share and 10% of the publisher's share. Some people make assumptions about a variety of things, and the problem with assumptions and different expectations. So it's good to just clarify these basics before you start registering songs with different organizations and telling your collection societies that you have certain things. You want to make sure that as between the people involved, that you're all on the exact same page.
Okay.
And so when I mentioned mechanical royalties, I'm generally talking kind of about the umbrella of publishing royalties. These are royalties that are going to the writers of music. When music is played on Spotify, for example, most of the money generated goes to whoever owns the master recording, but there is money that's generated that's going to SOCAN, and there's money generated that's mechanical royalties that are collected easiest by a publishing administrator. So Yeah, I would suggest having a publishing administrator, and there are several that are out there. Especially if the music is being played internationally a lot. Even more reason to have a publishing administrator help to collect royalties that are generated around the world. You also want to make sure that, like, if the artist that you're working with is performing these songs around the world or here in Canada, you want to make sure that they're registering every show they do with SOCAN to ensure that money from, like, SOCAN money from the performance is actually paid. You want to make sure that the venue is actually paying, and you also want to make sure that you're providing SOCAN with the appropriate and complete information so that the public performance royalties that are generated when the music is performed publicly in person, that all the dots are connected, and SOCAN receives the money and pays it out. And if you're getting 10%, then you're getting 10% of that.
Right on. Well, I guess that answers Patty Hunter's question. There's a bunch more here to do with rights and royalties. Let's save those for the end. We can cast a wider net, get to as many. But one more that goes back to that last slide about lawyers specifically. Vanessa asks for advice on choosing a music lawyer if there are none in your community, if you're maybe in a non-urban center somewhere in the country.
Sure. Well, I'm sure most music lawyers, including me, work with people across Canada. I live in Ottawa. I go to Toronto for different events like Canadian Music Week and Folk Music Ontario. I've been up a variety of things in Northern Ontario for presentations there in Quebec, but like I work with people in Vancouver, Winnipeg, out east, mostly in Ontario, but not exclusively. And even people that are in Ottawa that I work with, I may not meet them until after I've done something, for them. So there's a variety of clients that I've worked for that I've never met. We talk on the phone, or we, Skype or Zoom or Slack or whatever. But you don't need to actually, meet each other. It is nice. Like whenever I go to a music conference, I try to connect with the artists that I've been working with but never met before. But definitely, no matter where you are, in Canada, I would think that every music lawyer, if not most of them, they don't care where you're based. You don't have to be based in Toronto to have a music career, it doesn't matter really where you're based. You can access services, including but not limited to a music lawyer wherever you are. Now, it helps to have an internet connection, but apart from that, yeah.
All right. Yes, we'll get to more cues shortly. Thank you, everyone, for the great fodder here. Zooming in on two specific and particularly common agreements in the music industry, those being music producer, which is one that you're likely to encounter even if you are an independent artist, all of the things standing. So let's jump into this. And we've got a few points here, although there's a little more that we can tack on to the end.
Yeah, I think so. So generally, I'd say the music producer relationship is one of the most common because, way fewer people have record label or publishing agreements or management agreements, but most people do have recorded music, and many of them use a producer to help them record the music. So what does a producer do? Generally, they oversee the production of the song, they record the performance, they produce it artistically, commercially, and to create commercially, artistically, and technically viable masters. So that's generally what a producer does. But every producer is different. And some kind of bring their vibe, and others create a beat. So you want to make sure from a creative perspective that you're working with a producer. You want to make sure that that he or she is the right kind of producer for you. And related to the relationship with the music producer on the business front. If the conversation concludes that you're paying the producer something, you may think that that's all you ever need to give to the producer, and the producer might think that that's an advance against future royalties and that they're being considered a co-author. So it's really important, to ask that question of what are your expectations of me and my music, for you as an artist to ask your producer, and if you're the producer, then to ask the artist, because you want to make sure you're on the same page about about what each party is giving to the other. And essentially, kind of in terms of like a spectrum of agreements here. On one end is that people just don't talk about what the relationship is. They just talk about how much money the artist is giving the producer. On the other end is a negotiated written agreement whereby there's one or two music lawyers involved, and they go back and forth on a detailed agreement. Most people land somewhere in between, but it is a good idea to talk about these things with your producer and hopefully to get them in writing. If you are thinking right now, oh, I just produced an album with producer X, and nothing was in writing. Before I said, is it too late to get things in writing? And the answer is no. Like, you can always go back to your producer that you produced an album with last week or 5 years ago and say, I just want to make sure we're on the same page about what my obligations are to you, and I want to confirm that I own the masters, et cetera, et cetera. You want to, I'll get into those specific things, but you can ask for something in writing from your producer, or propose something in writing to your producer after the music has already been recorded. Preferably it's done in advance, but it doesn't need to be done in advance. And usually a producer agreement would outline some logistics, like where the music's being recorded, when the music is being, what is being delivered, when it's being delivered, what the approval process is, and specifically what the deliverables are, because some people have different expectations about what you're supposed to actually get from your producer. So that's kind of the relationship. As for compensating the producer, usually it's it might be a combination of money up front and money that's contingent upon the music earning money. So if you're paying money up front, the question is, what are you paying? What's the payment schedule? As an artist, you want to avoid paying everything up front. And as a producer, you want to avoid getting paid everything once you've delivered everything. So, usually what happens is that, some money is paid up front and some other money is paid later on. The question about later on is that last payment based on when the producer gives the artist something, or when the artist approves something? So, the final payment, it's important to clarify what exactly triggers that final payment. And as for what I'd call contingent compensation, meaning that money that you may, as the artist, pay the producer, some of the ways that money might be generated is from digital sales of the music, or even physical sales if you have any. So, are you giving the producer a percentage of profit? Are you paying them a percentage of gross sales? There's a variety of different formulas about that. Are you getting paid as soon as there are sales, or once the artist has paid for their costs? Is the money recoupable? Meaning, like, let's say that you pay the producer $2,000 to record 2 songs, let's say. Ideally, as the artist, you want to have all that money being recoupable, which means that if you're paying the producer $2,000 and also paying her 10% of the money you make from your music, if the $2,000 is recoupable, it means that the first $2,000 that you would otherwise pay the producer from sales of the music isn't paid to the producer. It's paid back to you as the artist. So as an artist, you want to have as much of the payment to the producer being recoupable as possible. And as a producer, you want to limit the amount of money that's recoupable. And usually if someone brings it up, you land somewhere in between, perhaps half the money being recoupable. But that could go a long way in saving you money as the artist once you start to make money from your music. We talked a bit about neighboring rights royalties in the Q&A, and your producer you may want to give your producer a percentage of the neighboring rights royalties that are generated. You want to clarify exactly what types of neighboring rights royalties you're talking about. You might pay the producer a percentage of the money you get from the master when you do a music placement of your music, or when there is a situation in which you're just given some money for the use of the master. And then we've touched on it before, but think of your producer potentially as your co-writer. Is your producer entitled to a percentage of the composition percentage of the composition? And it's an important, point to bring up, ideally proactively. If the producer is if you're an artist and you bring a producer a melody and full lyrics, and the producer is essentially, recording you and adding a few little things here or there, but isn't contributing at all to the lyrics and isn't contributing too much to the melody, etc., or the beat. The artist may have the artist may have a reasonable position that the producer shouldn't be entitled to any of the composition. But if the artist brings in the lyrics and the producer creates the entire beat for the song, that's an entirely different scenario. And it might be that you share the composition equally with the producer. So it's important to, proactively figure that out. And then, if the producer is being given a percentage of the composition, do you want the producer to be making decisions about the composition, or do you as the artist want to be making all decisions about the composition? So that's something to figure out. A couple of last things about producer agreement details. What credit is the producer getting? Are they being credited as producer? Probably. As co-writer? Probably not. Maybe not. You want to confirm that what the producer is doing is original. And there's a variety of other things, but I'd say the most important thing by far in the producer agreement is confirming that you, the artist, own the master. So that's what you want to confirm as the artist. I said that's the most important thing, but probably the very most important thing is who the producer is. You want to make sure that it's the right person for you for this project at this time. So you want to do as much due diligence as you can to ensure you're working with the right person as your producer. But maybe the next most important thing is that you own the master, that you, the artist, own the master. And the third most important thing, I hate to prioritize things, but I guess another important thing, as I've outlined, is what your obligations are, if any, to the producer. If the producer is being given a fee and that's all she's ever going to get the producer to clarify in writing that the producer received their full fee. They aren't obligated. You aren't obligated to pay them anything else. They aren't owed anything else. They have 0% of the composition. They aren't being given any credit apart from produced by credit, and that you, the artist, own the master. So even if the producer just says that you have these things, get them to confirm it, in an agreement or by email or something in writing.
Right. Let's jump in. How are we for time? Okay, we're doing okay. After management agreements, we will share some general negotiating tips and agreement, kind of more FAQs, and then the red flags, which I guess we can race through. So
for sure. So yeah, I mean, in terms of management, similar to my last comment on producers, the most important element of a management agreement is who the manager is, or if you're a manager, who the artist is. This is a professional relationship. It's essentially like a music marriage. You want to make sure you are, professionally marrying the right person. And it is hard to know. Usually people date in real life more before they get married, a lot longer than they work with a manager before they start working with a manager professionally. So, you want to make sure you're working with the right person or people. So management agreements, when should they be prepared and signed? Preferably earlier on in the relationship to clarify everybody's rights and obligations, but again, it can be done later on if needed. Are the manager's services exclusive? So usually a manager is allowed to work with more than one artist, unless that's not the case in your scenario, but many managers work with more than one client. What are the specific tasks and authorities? So it's really important to clarify what the manager is actually doing, so that both sides are on the same page, that the expectations are aligned about what the manager is actually doing, and what the manager has approval to do or the right to do without your approval. So if you want the manager to have the right to book you shows, that should be clarified. If you don't want the manager to do anything without your approval, that's something that would be important to discuss with the manager and have in your agreement. What's the term or duration of the deal? So preferably as an artist, the length, the duration of your arrangement is short term. And as a manager, you want it to be longer term. I've seen everything from essentially no term, meaning like it could end any time, up to 5 years. I think, a year or two is more reasonable than 5 years, but it depends. What compensation is the manager entitled to receive? Well, the manager usually receives a percentage of something. The question is, what is the percentage? Is it 10%? Is it 15%? Is it 20%? whatever it is, multiplied by what? Are they getting a percentage of everything, or are they getting a percentage of everything except for your writing royalties, or everything except for, you know, some sort of opportunity that you arranged before you met with the manager? Really important to clarify the scope of the percentage. If a manager says to you, I want to, you know, get 15%, that means not essentially nothing, but close to nothing, because you don't really know what it's a percentage of. You want to really clarify what the scope is. Can the commission vary? So yeah, I mean, it could be 10% of everything but touring and 15% of touring, because they're also kind of your tour manager. It doesn't have to be the same percentage for everything, and it could be 0% for some things. When does the scope of the work start? So, you know, preferably you clarify when you started, even if you write like if the agreement is prepared today on June 25th, 2019, if you started working together on January 1st, 2019, then your agreement would be dated January 1st, 2019, and the manager's commission would be, you know, relating to the money earned since January 1st, or whatever you decide. What does the manager get after the agreement ends? So this is generally called a sunset clause. The manager might be entitled, if it's in the agreement, to a certain percentage of certain types of royalties for a certain amount of time. Again, I don't think I've ever seen two sunset agreements that have been the exact same. They all vary somewhat. But the question is it reasonable? So is it reasonable that you keep paying the manager something after you stop working together? Depends on the situation, and there may be other, you know, clauses added to the agreement that provide more protection for the artist. What's the cash flow? So it's important to decide, like, is the money flowing from shows and royalties from artist, and the artist pays manager, or does it flow, does the manager get paid and then the manager pays her client at the end of every month, or whatever it is? So it's important to clarify that proactively. How do expenses and loans work? So sometimes some managers pay for expenses and then eventually, you know, get reimbursed by the artist. So you want to clarify on both, whether you're the artist or the manager, you know, what your entitlements are to buy things, and what the obligations are of the artist to pay you back. I probably have a management agreement blog on my website. So if you go into the link that we'll provide for the website, there's a manager agreement blog that goes into some of these things in a bit more detail. But I work with both managers and artists, so I've represented managers with management agreements and artists with manager agreements. Obviously, not this. I would never represent a manager and an artist in the same scenario, but I work on both sides. And sometimes I work with managers to help them with their artists, and I never speak or meet with the artist ever. But I'm, you know, working with the manager to help to protect their artists by reviewing their artists' agreements without ever having talked to the artists directly or meeting with them in person.
Okay. More questions coming in here. In fact, I think we may have to cap this shortly.
Yeah, and if there are other questions, you know, we can. Well, do you want to? I could do the next two like pretty quickly here.
Let's do it. We'll jump into questions. See how we can get there.
Yeah, so these are kind of general tips for a variety of music agreements. It was written initially for record label agreements, but it applies to a variety of things. You don't need to sign really. So if you're the artist and if you're a producer and an artist wants to work with you, you know, you can say no, or you know, you can say no to a variety of things, and you should say no if it's not the right, you know, fit for you at the time. So just because someone gives you an offer to do something, it doesn't mean you have to, you know, agree or negotiate. You could just say no from the start. It's not just about the money. So, you know, it's also for any agreement that you're involved in, other relevant issues are control and credit. It's really not it's not just about the money, but, you know, money is one important factor, but it's not the only one. The main reason for signing, so if you want to sign, let's say with a record label, because they are promising to produce 500 vinyl copies for you that you can sell at your shows, well, you know, ensure that whatever is the main reason for you for signing is actually in your agreement. Because if the label doesn't do that, then you can, depending on your agreement, end the agreement early. So if someone's promising you something, try to get it included in the agreement. And if they won't include it in the agreement, that may be a sign that they're not actually going to do what they promised to do. Know your motivation, so know kind of why you're wanting to sign with someone or enter into an agreement. And that's kind of similar to the previous comment. Don't make the first offer. So if you're a producer or if you're an artist and you're talking to a producer about recording your EP, instead of telling the producer what you can afford, ask the producer what their costs are. So general negotiation tip, but try to get the other side to make the first offer. You can't always get what you want. Usually when I'm reviewing an agreement and making suggested changes on it, the other side, whoever they are, usually accepts some things and doesn't accept other things. It's difficult, although not impossible, but difficult to get everything that you could possibly want in an agreement with someone else. Create leverage. So the more interest there is in you from other people, likely the better deal you'll get from the people who are trying to work with you. You're not tired of waiting. Repeat. The most common issue I find with people with music agreements is that they're frustrated by the amount of time that things take to get done. And sometimes will agree to enter into an agreement because they don't want to wait around to get a better deal. And my general comment is, don't be tired of waiting. Things take a while. Try to be patient. I know it's frustrating, but better to try to make sure you get the best deal that you can, as opposed to just taking whatever's in front of you because it can happen faster. That doesn't always apply, but usually is relevant. Who else is signing this agreement? The most important thing of any agreement, music or otherwise, is who the other people are that you're working with. You want to make sure you're writing, again, I've mentioned this a few times, but you want to make sure you're working with the right people at the right time for the right project. A great agreement with a bad partner is a lot worse than a mediocre agreement with a really good partner. And then the next one is about some music agreement red flags, like things to watch out for. Inconsistency. So sometimes you're told something and then the agreement is just inconsistent with what you're being told. So when I'm reviewing an agreement, I ask someone, well, what were you told? Like, what were your expectations about what would be in this agreement, so we can ensure that what you're told by, let's say, the producer or the A&R person is consistent with what's actually in the agreement that you're being asked to sign. Being asked to give more rights than are needed. So if you're working with someone who's distributing your music, then you don't also have to give them publishing rights to your music. They don't need that in order to distribute your music. So something I always look out for is when someone asks in writing for more rights than what is actually needed for that person to do what they're looking to do. Lack of clarity. If things aren't clear now, then it'll be an issue later on if there's a dispute between the parties. So oftentimes what I'm doing when I'm reviewing an agreement is adding clarity to ensure that things are very simple and straightforward. And I may say, it may say blah blah blah, and I would say, for example, this means that if blah 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 happens, then whatever happens. So it's important to ensure that your agreement with whoever it is very clear. The next few are mostly record label specific. Lack of balanced rights. At the end of an agreement that a lawyer writes, usually there's a variety of statements that are kind of labeled as miscellaneous or general. Just because they're general or miscellaneous doesn't mean that they don't mean anything. It doesn't mean that they couldn't be more balanced. So it's important, with everything with any agreement, to read the whole thing, but also just to recognize that kind of the stuff at the end that may be in the fine print or whatever, like that could actually make all the difference in the world. So it's important to ensure that there are balanced rights in the agreement regarding some of that kind of stuff, as opposed to just not reading it and assuming that everything's fine and agreeing to terms that aren't balanced and appropriate. I do have a couple blogs about music agreement tips and music agreement red flags that are on my website, or if you email me, I can send them to you. I didn't include them with the stuff today because I think the most important, if you're going to read any blog, I think you should read the blog about what are your expectations of me and my music. But there are some other blogs that relate to these topics too on the site.
Bang on. And we will put up that URL momentarily. So here we go. Questions, comments. We've got a lot in the queue. We'll probably have to cap it with what's here. If you've got anything really burning, send it over and we'll try to get to it now, or if not, Byron's been very generous with his time and agreed to take some things after the session. So on that note, one more shout out for Edwards PC Creative Law, edwardslaw.ca. And there's links here to find them on socials, as well as Byron's direct email address for some of these as well. So let's roll through. Just because of time, if the question had to do with defining a certain term or something, I certainly don't mean to patronize, but that may be one that could just as easily be directed at Google. Here we go. Okay. Oh, sorry, we already asked that one. This is a very specific and interesting question. I was totally lost. Are neighboring rights collected on a master that's broadcast as part of a sync deal, but that hasn't been commercially released on a CD or streaming service, etc.?
Yes.
Okay. Spotify, who collects royalties from Spotify? SOCAN?
Well, they are one of them. But as I mentioned before, the three main avenues from streaming platforms like Spotify would be money that is paid to the license to use the master. So if you're using, let's say, DistroKid or TuneCore or CD Baby, the money you're getting from them to have the music be on those platforms is because you own the master and you're giving a license to use it. But the other royalties that are generated are mechanical royalties and performance rights royalties. If you're registered with SOCAN, that's how you're accessing the performance rights royalties. And my suggestion generally with mechanical royalties is to work with a publishing administrator to make sure that they're collecting all of your royalties, all of your mechanical royalties from all, let's say, avenues and platforms, including but not limited to Spotify.
All right. Here we go. Outside of rights and royalties.
And sorry, one other note on that, just a quick note on that. I keep mentioning Songtrust, but there are others. But I mean, I've emailed Songtrust and I said, you know, on these songs, an artist is considering using you. What would be the estimated royalties that would be generated if you were to help them collect? And they will provide you the answer. If you just go on their website, if you put in some music, I'm assuming they still do this because they did it a few months ago. They'll just, you know, they'll give you some numbers. So that may be helpful to get a better sense. And again, I don't work for Songtrust, but they do put on some good webinars about these issues. And you know, I'd suggest looking into all the different music or publishing administrators. And there are some Canadian-based ones, there are some US-based ones. But whether you're an artist or a producer, if you are, you know, writing in any way, it's a good idea to learn more about the role of a publishing administrator if you don't have a publisher. If you have a publisher, your publisher is, you know, I don't want to say 100% of the time, but, you know, most likely playing the role of your publishing administrator. Most people don't have a publisher. And I would, you know, highly suggest looking into getting a publishing administrator involved to ensure you're accessing all the money that you're entitled to as a writer or co-writer of compositions, whether you are the artist or not.
Right. Our friend Alan from the CFM often joins us for these. I would give this one right to him if I could, but alas, as a writer or producer, I'm occasionally hiring musicians to track a particular instrument on a song I'm working on. They're generally given a per track one-time sum arranged ahead of time. Do they have rights to royalties?
I'd say the broader question is anybody entitled to royalties? And it's important to decide that up front with the people that are involved in your project. I have a client who there's, let's say, 4 of them involved with a project. 2 of them are not writers at all, but they decided that they would split their SOCAN royalties 25% each, because that's a way that they can help to ensure they're all compensated, even though they aren't, that they're all compensated from the writing, even though, you know, 2 of them aren't writers. Sometimes when you're hiring musicians to join a recording, you would clarify what percentage of the featured or non-featured performer neighboring rights royalties everybody's entitled to get. But, you know, if you, and I'll segue for a second there, for neighboring rights royalties, as I said before, well, half of it is for performance and half of it is for owning the masters. On the performance side, there's another division between featured performers and non-featured performers. Right. And there's a different percentage of that in Canada and the US. It's more in Canada for non-featured, but either way, if you're a session musician, you want to clarify for everything that you record on what your percentage is of the either featured performer or more likely non-featured performer royalties. But if you're a session musician and you're writing, music, you should clarify with the artist, the kind of, let's call him or her the main artist in the situation, what percentage, if any, you're getting of the writing royalties. And it may be reasonable that you get, a small percentage of the writer's share, but maybe not a percentage of the publisher's share. But it's important to clarify this early on with the people that you're working with. And I guess another point to that is that you may, as the musician who's performing, you may have a bit more leverage to get a higher percentage if you are not being paid your full normal rate. But if you're being paid your full normal rate or more, as dictated by CFM or otherwise, it may be decided that you have a bit less leverage to get a percentage of these of relevant royalties. So the bottom line is to proactively have an open and honest discussion in advance. The singer-songwriter, artist is usually the one who's taking the risk to, pay people out of money they got from, their friend or their, in-laws or factor or whatever. They're the ones taking the risk here. And so there's reason why that person should be entitled to, the lion's share of the reward if there is one. But, it's important to clarify these things proactively. And just because someone isn't in the band or isn't on a recording or isn't a writer doesn't mean that you can't all collectively agree that they receive a percentage of the writer's share. I mean, the manager could be given a percentage of the writer's share if you want. SOCAN doesn't say, oh, does this person actually write? They say, who do you want to have be split? Who do you want to be given a percentage of the writer's share or the writer's share and the publisher's share of the song? They aren't, checking to make sure that you actually, they aren't checking to make sure that the 20% person actually wrote 20% of the composition. It's a bit of a tangent there, but hopefully that that answers the question and maybe answers a few other related questions.
Right on. Fun, I guess, kind of segments into two parts if we can keep it simple. Legal considerations a musician should consider if performing another person's song in Canada. If we're just talking like a cover song at a gig or a open mic or something, pretty basic. And the other side is about recording a song not belonging to selling it. That is a very different issue.
Right. So once a song has been published, meaning like once it's been recorded, once the original writer of a song has, let's say, performed it, anybody can perform it after that, like live. If Andrew writes a song and I look at the song, I can't go perform it live until he either gives me permission or once he's performed it. But once someone has, let's say, gone public with their song, anyone else can perform it live. And the way that they're compensated is that if you're in a venue that would meet the thresholds to pay SOCAN, if you're in Canada, then the venue or the promoter or someone there would be paying SOCAN the relevant tariff. And the artist would give SOCAN the relevant information about their set list and other information. And then the writer of that song, who didn't even know that you exist as the artist and didn't know you're performing at the venue, would be paid something based on you performing their composition. If you are, so that's kind of the public performance thing. If you're recording it, that's a different scenario. And the most kind of common example, or one of the common examples, is that if you are recording a CD and let's say it has 10 songs and you have a cover song by, whoever, you can buy a mechanical license from CMRRA if the publishers of that song are members, and you pay them a fee of approximately, let's say, 8.3 cents multiplied by the amount of recordings, but there's a minimum of 500. So like you're paying for the right to make copies of the recording. And some of the other uses of recorded songs that are written by somebody else, their publishing royalties are collected by those publishing administrators. But those are some that kind of scratches the surface a little bit about using other people's works. either in performance or recorded form.
Can your firm submit songs to celebrities who will not accept unsolicited material?
It depends. We've made some interesting requests, but I'll answer that with it depends, and we can leave it at that. But many music lawyers or lawyers in general, let's say music lawyers, do try to create opportunities for their clients, or some of them, depending on the situation. And I think the takeaway for more people than just the person who asked that question is that the lawyer is really one other member of your team who's looking out for you as an artist. And the more that the lawyer knows about what your aspirations are and what your projects are and what you have on the go and who you want to work with as a producer or a publisher or a label or who you want to tour, like the more they know about what you want to do, the better they can help. And they may either help or not, depends on the situation. But if they know about your needs and interests and aspirations, and the more they know, the better they can help.
All right, on. Thank you very much, everyone. If we didn't get to your question, rest assured, I will be in communication with Byron, and we'll share some of these, and let him be even more generous with his time to get some responses. In the meantime, though, thanks to him and huge thanks to you for joining us. So we bled a bit over the hour, so I appreciate the attention and the great questions. It was very engaging. I learned a lot, which was great for me. So yeah, thank you for joining us. Anyone listening to the sound of my voice right now will get an email at some point tomorrow with a link to a recording of the whole session. Feel free to revisit, share, anything you like. Again, nwcwebinars.com. Get registered for next month. We'll have the rock doctor, Mike Schwartz, joining us to help you keep at peak performance levels with your body and mind. And that's also where you can access our archives, all of the previous sessions, including Byron's on band agreements, including one with a couple on music publishing with some very successful publishers. We'll answer a lot of these questions if you're looking to dive in a little deeper. And thank you very much, too, for the kind words that are now coming in as I speak. We'll share these with Byron as well. So cheers, everybody. As soon as I kill a recording here, I will lose you. But it's always a pleasure. We do these for you. And Byron, a formal thank you for joining us and being so generous with your time and information.
Thanks, Andrew, for this and for all that you guys do. It's great.
All right. We'll catch you next